Hello everyone. So my today's topic is proof and verification of documents. So to begin with it, in Indian law there are two methods for proving the facts of a particular document: oral evidence and documentary evidence. These two methods are discussed in chapter 4 and 5 of the Evidence Act. Let's see what chapter 4 and chapter 5 contains. Chapter 4 of the Indian Evidence Act deals with oral evidence, specifically in section 59 and 60. This chapter lays out the rules and procedures for presenting oral evidence in court. Chapter 5, on the other hand, focuses on the documentary evidence and is composed of section 61 to 90A. Section 3 of the chapter define what constitutes documentary evidence, while section 61 to 65 outlines the method for proving a fact using a documentary evidence. So, in chapter 4 and chapter 5, the methods are discussed on how a particular document is to be proved. Moving forward to the meaning of documentary evidence. Documentary evidence refers to any material object that is presented to a court as a proof of a fact. It may include any physical object such as contract, invoices, photographs, emails. The purpose of documentary evidence in the legal system is to provide objective and reliable proof of the existence of facts that are relevant to the legal proceedings. Furthermore, now we'll discuss the provisions that are related to our topic which are given under the Indian Evidence Act. Section 3. Section 3 is the interpretation clause. This section defines the term document to include any substance on which matter is expressed or described by letters, figures, marks, or more than one means and that can be used for recording the matter. Document basically means which is expressed through letters and figures. The definition of a term is very broad and encompasses various types of records, including paper documents in different languages, banners, symbols, etc. Section 61. Proofs and contents of documents. Section 61 requires that the contents of document must be proved by either primary evidence or secondary evidence. No other methods are allowed to prove the contents of the documents. Section 62. Primary evidence. Under section 62, the definition of primary evidence is given. It states that the original document itself produced to the court for inspection is primary evidence. The original document of anything is the primary evidence. It is considered the best evidence, providing the greatest certainty of the fact in issue. Section 63 contains secondary evidence. Secondary evidence is a certified copy of the original document, which means the certified copy of a primary evidence. It also allows for an oral statement given by a person about the contents of a document after reading it. However, secondary evidence is only considered under certain circumstances. Moving forward to section 64, which contains the proof of documents by primary evidence. Section 64 outlines the best evidence rule for documentary evidence in the Indian Evidence Act, stating that the best evidence of the contents of the document is the original document itself. The contents of the document must be proved by producing the original in court. Section 65, which is the next section, is an exception to section 64. Section 65. Cases or circumstances in which secondary evidence relating to documents may be given. Before presenting secondary evidence, the conditions stated in this section, which is section 65, must be fulfilled and the non-production of the original must be accounted for in a way that brings it under one of the conditions provided. This section is meant to protect the rights of those who are unable to present primary evidence due to the circumstances beyond the control. So section 65 is an exception rule to section 64. Section 64 was proof of documents by primary evidence. Next, it is a case of state NCT of Delhi versus Navjot Sandhu. In this case, the issue was that whether a phone call records to be admissible evidence in court. So the court decided under this case that uh, it made an exception to the rule for secondary evidence given under Section 65A. The court held that phone call records are considered secondary evidence because the primary evidence would be the information stored by the telecom servers. So, this is a case in which the court made an exception. Moving forward to Section 66, which is notice to provide a documentary evidence in Indian Evidence Act. Section 66 of the Act requires a notice to produce when the possession of the original document is with some other party. This notice must be given to the person's attorney, and failure to do so restrict the presentation of the original document. Section 164 of the Act states that if a party refuses to produce a document, they cannot produce it later without the other party consent. Section 67 to Section 73A deals with the documents that need to be attested. Means that they must be proof genuine in court. Attestations serve as evidence or proof or something. Section 68 of the Act deals with the proof of documents that require attestation. It states that such documents cannot be accepted as evidence in the court unless they have been attested in the presence of at least one attesting witness as required by law. Attested means to be considered genuine, to be genuine in the court. However, there is an exception to this rule in case where a will has been registered under the Indian Registration Act of 1908. The attesting witness need not be present in court unless the executor denies executing the will, or if there is evidence or false or tampered execution. When attester is absent, so this problem is dealt under Section 65, that what happens when the attester is absent. So under Section 69 it is mentioned that when the attester is absent and when the situation arises where the document was executed in the UK or where a new witness is available, it must be proved that the signature and handwriting of the executor and the attesting witnesses match. Section 70. Admission by party to attested document. Section 70 deals with a situation where a party admits to having executed the attested document even if it was required to be attested following the law. Admission under Section 70 is not the same as admission under Section 22. If a person admits to executing a sale deed and to have signed the document but denies the presence of any witnesses, the attesting witness must be called under Section 68 to prove the bond. Section 67. Proof when an attesting witness denies or forgets. Section 71 deals with the situation when the attesting witness denies or forgets having executed a document. In such cases, the documents can be proved by other evidences. So, other evidences are required to prove the said document. Section 72. Proof of unattested documents. Section 72 states that if a document is attested, when it does not require attestation, it can still be proved as unattested. To prove an unattested document, it is necessary to prove that it is attested and the signature matches. To prove that an attested document, it is necessary to prove that it is attested and that the signature matches. However, to prove an unattested document, only execution needs to be proved. Section 73. Proof of signature, writing or seal. Section 73 states that when there is a question about proving a signature, writing or seal of a particular person, it may be proved with the help of any written matter, signature, writing or seal of that particular person which has already been admitted or proved in the court to be valid. The court has discretionary power in this matter. Now, I would like to conclude my topic. So, documentary evidence plays a crucial role in the legal system and is widely used in courts to prove facts and establish truth. The Indian Evidence Act provide for various provisions relating to the admissibility of proof of documentary evidence. From section 61 to 73, the Act covers different aspects of documentary evidence such as proof of handwriting, attestation, admission by parties, and exception to the rule of attestation. It is important to note that documentary evidence has to be properly authenticated and the accuracy of the record must be established for it to be admissible in court. Thank you so much.